Okay, let's unpack this. Picture a scene that, on the surface, looks identical to a criminal act. You've got two people standing over another person, and one is about to make a sharp incision into their flesh, draw blood, and cause a physical change.
Hmm.
But this isn't a crime, it's surgery. This is, I think, the fundamental puzzle we could call the surgical paradox. What is it that separates the surgeon who cuts and causes pain from, a criminal?
Well, it boils down entirely to one word:
No.
intention.
Intention.
If you trace this back through legal history, a criminal is acting with the intention to cause harm, or is just, reckless about it. The surgeon's intention, on the other hand, is limited solely to treating an illness.
Right.
Any harm that results, the cut itself or even a really severe unexpected complication, is either just necessary to get to the therapeutic goal or it's purely unintentional. And that single distinction is the legal bedrock that allows surgery to even exist.
And that bedrock of intention is exactly what we're drilling down into today. Welcome to a deep dive into the dense, crucial, and frankly, sometimes surprising legal and ethical world of surgical practice. We're focusing on the principles laid out in Chapter 14 of the 28th edition of Baily and Love's textbook.
And this is such a critical chapter for anyone in the clinical world. I mean, while the concepts are rooted very heavily in English law, the core principles, the ethics of it all, they're universally relevant. These UK frameworks often become models for jurisdictions all over the globe.
Exactly. And let's be really clear about our mission here. We are not trying to replace the textbook. This is an interpretation, a clarification designed to make these complex ideas really stick. Think of this as your ready reckoner, your high-yield revision tool, or maybe the anchor you set before you dive into the main text. We want to give you those aha moments that make it all click.
And over the next half hour or so, we're going to unpack the true meaning of patient autonomy, the really detailed requirements for informed consent, and all the legal pitfalls there, the duty of candor, and then how decisions get made when patients can't make them for themselves.
Plus, that incredibly tricky tightrope walk between confidentiality and preventing serious harm. That's a huge amount to cover, so let's dive straight in with the foundational pillar of all of this: respect for autonomy.
Right. So the core concept is this. A surgeon's duty of care goes way beyond just, preserving life and health. Their duty is to respect the patient's autonomy, their ability to self-govern.
Which means the patient has to be able to choose and evaluate outcomes based on their own life plans, right? Not the surgeon's.
Precisely. Your job, your hobbies, your family, all of that matters. I think that phrase, other life plans, is so powerful because it forces us out of that purely clinical mindset.
Yeah, a complication that's maybe a minor issue for an office worker, say. Some numbness in their hand could be absolutely career-ending for a concert pianist. The surgeon can't just assume what the patient values most.
Exactly. And this whole idea underpins what we might call the surgical contract. The patient is letting you do something hazardous to them. They have to retain control over who they allow to touch them and why. That's where the trust comes from.
And if they have the right to choose a treatment, then logically they must also have the right to refuse it.
Yes. And this holds even if the surgeon, the family, everyone thinks the refusal is reckless or just plain wrong.
This is where it gets really tested, isn't it?
It is. There's a landmark case the source mentions about a woman with full capacity who refused renal replacement therapy. She knew it probably lead to her death.
And the court's decision.
It was decisive. The court basically said that just because her decision seems unreasonable or illogical or even immoral to other people, that alone is not evidence she lacks capacity.
Wow. That sets an incredibly high bar. As a professional, you're trained to save lives. It must be so difficult to stand by and watch a patient make what feels like the wrong choice.
It is, but it requires a mental shift. Your duty moves from saving the patient to ensuring the decision is truly autonomous. If they have capacity, they understand the facts, the risks, the alternatives. Then your professional duty is done. To override that would be a violation of their bodily integrity.
And this isn't just a right for the here and now, is it? Patients can project this refusal into the future.
That's right. That's where things like advanced decisions or a lasting power of attorney come in. There are legal tools that let a patient specify treatments they would refuse, like being put on a ventilator, if they later become incompetent and can't speak for themselves. Their autonomy endures.
Okay, so if autonomy is the patient's right to control their own body, that leads us directly to how the surgeon actually enables that control. And that has to be disclosure and valid consent.
Absolutely. Section 2. This is where the philosophy meets the daily grind of clinical practice.
And the biggest barrier here is what the book calls the understanding gap. The huge difference in knowledge between the expert surgeon and a patient who's probably scared and overwhelmed.
It's monumental. The example they give is perfect. How many patients would ever guess that a surgery on one eye carries a tiny, tiny risk of blindness in the other eye?
It's not intuitive at all. And without being told that, their choice isn't truly informed.
Which is why disclosure has to be so personal.
Yeah.
Let's create a fictional case to really hammer this home. Let's call her the budding Olympic gymnast.
Okay.
She has a small, benign lesion in her neck. The surgeon says, let's take it out to prevent future problems. The risk of nicking the accessory nerve is tiny, maybe 1%.
To a surgeon, 1% is negligible.
But if that gymnast is told that cutting that nerve would mess up her trapezius muscle, cause chronic shoulder problems, and would absolutely end her Olympic dream, she might rationally choose to just monitor the lesion for years.
Right. She'd take the risk of the lesion over the risk to her entire life plan. The surgeon has no right to withhold that information.
None at all. Without that specific piece of information, her consent is invalid.
So what exactly must be disclosed? The guidance from the Department of Health and the GMC lists 6 essential elements. We should probably detail them.
We should. So number 1, the condition itself and why surgery is needed now.
2, the type of surgery proposed and how it's supposed to fix the problem.
3, the anticipated prognosis and the expected side effects. Pain, scarring, recovery time.
4, the unexpected hazards, the list of complications.
5, alternative treatments that might also work, including non-surgical options.
And number 6, which I think is so important, the consequences of doing nothing at all.
Yes, you need that baseline to compare against. But it's not just the information, it's the circumstances in which you give it.
You mean creating the right environment?
Exactly. A quiet room, not a busy corridor. Using diagrams or written materials. And crucially, giving the patient time to actually think about it, to talk to their family.
And a huge one that often gets overlooked in busy hospitals. The person getting the consent should ideally be the person doing the surgery.
Yes, because a junior doctor, however capable, just doesn't have that deep, nuanced understanding of the specific risks for that patient with that anatomy, using the technique the senior surgeon plans to use.
The liability still rests with the operating surgeon at the end of the day.
It does. And beyond all that, it's about basic communication skills. No jargon. Use professional translators, and, most importantly, you have to test their understanding.
Not just any questions.
No, you have to say, can you tell me in your own words what we're going to do and what the biggest risks are? If they can't, you haven't finished the job.
Okay, so now we get to the sharp end. The legal risks if you fail to disclose properly. There are 2 main civil actions a surgeon could face.
Right. The first one is battery. This is basically intentional touching without consent. It happens when the patient agrees to be touched for procedure A and the surgeon does procedure B or adds something extra.
So battery is about the scope of the touching, what you were allowed to do. The second one, negligence, is more about the quality of the conversation, isn't it?
Exactly. With negligence, the patient did agree to the procedure. They consented to be touched. But their argument is that the surgeon failed in their professional duty to provide enough information about the risks.
They're essentially saying, I would not have agreed if I'd known about this particular risk.
Precisely. And this whole way of thinking was cemented in UK law by the massive 2015 case, Montgomery v. Lanarkshire Health Board.
This case really changed everything for consent, didn't it?
It completely upended the old doctor knows best model. Before Montgomery, the standard was basically whether other doctors would have done the same thing.
The Bolam test.
Right. Montgomery threw that out for risk disclosure. It said the surgeon has to tell a patient about any material risk. And a risk is material if a reasonable person in the patient's position would think it's significant, or if the doctor knows that this particular patient would.
So that brings us right back to our Olympic gymnast. The risk is material to her, even if it isn't to someone else.
Exactly. The focus shifted from the profession's view to the patient's view. It's about their values, not ours.
And yet, despite all this, we still have what you could call the consent form myth. This idea that a signature solves everything.
It's so persistent. But a signed form is just a piece of paper. It's evidence that a conversation might have happened. It says nothing about the quality of that conversation or what the patient actually understood.
The source mentions that professional guidance is moving away from the form itself.
It is. The gold standard is becoming good clinical notes. A brief, accurate note in the patient's record detailing the key risks you discussed and confirming their understanding. That's far more powerful evidence than a signature.
Okay, that's a critical point. Let's make sure everyone listening has really grasped the difference between battery and negligence. Here's a check-in question for you. If a patient consented to an appendectomy but woke up to find the surgeon had also removed a large benign skin tag from their abdomen while they were in there, which legal claim is most likely? Battery or negligence?
Think about what they agreed to be touched for. Did that agreement cover the skin tag? The surgeon's intention was maybe good, but was the action authorized?
Pause and think if you need to. The answer is, because the consent didn't extend to the skin tag, that extra unauthorized touching is most likely battery.
That's right. He went beyond the scope of the consent. And that leads us perfectly into what happens when an authorized intervention goes wrong, which is the duty of candor.
Right. Section 3, the duty of candor, the obligation, to be honest.
It's a non-negotiable duty to disclose when something went wrong during an intervention that caused or could have caused harm or distress. It's all about maintaining trust after a bad event.
But surgery is complicated. How do you distinguish between a complication that's just part of the disease and one that was caused by the surgery itself? That seems like a really blurry line.
It can be, but the distinction is crucial. The duty of candor only applies to surgical misadventures or complications. It does not apply to complications of the disease itself.
Let's use some examples. A surgical misadventure would be, say, accidentally cutting the ureter during a hysterectomy.
Right, or leaving a swab behind. These are things that happen because of the intervention. Even if uretic injury was listed as a risk on the consent form, when it actually happens, the duty of candor is triggered. You have to tell them.
Okay, and an example of a complication of the disease itself.
A patient with advanced rectal cancer comes in and already has a deep vein thrombosis, a DVT. That DVT is a complication of their cancer, not of anything you've done yet. So no duty of candor is owed for that.
What if that SARA patient has surgery and 3 days later gets a massive pulmonary embolism because the team forgot to give them their standard post-op blood thinners?
Now the situation is flipped. The failure to follow protocol, the missed medication, is the something that went wrong. It's directly related to their surgical management. So a duty of candor would absolutely be owed in that case.
It's also really important to stress that fault isn't the deciding factor here, is it?
Not at all. The duty exists whether or not someone was negligent. Even if that ureter injury was totally unavoidable because of dense scar tissue, the patient still has a right to know what happened. They need that information for their future care.
What about the timing of all this? Do you have to explain everything, including who was to blame, right away?
No, the guidance suggests a staged approach. You must be candid about the fact of the complication immediately. The patient needs to know what happened. But candor about fault and causation, why did this happen, that might require an investigation. It's better to get the facts straight than to rush and mislead the patient.
So deliver the facts now and the full explanation after a proper review. That makes sense.
Okay, this takes us into another hugely complex area. Section 4, capacity and incapacity, making decisions when the patient can't.
And we can start with the most urgent scenario, emergencies.
Right, 4A, emergencies and necessity.
The doctrine of medical necessity is the old common law safety net. In a true emergency, life or limb is at stake. A surgeon can operate without consent if it's in the patient's best interests. This is what we use for unconscious trauma patients every day.
And this has now been backed up by statute, like the Mental Capacity Act 2005 in the UK.
Exactly. The MCA provides that legal backup, authorizing necessary and proportionate steps to save life. But even in a dire emergency, the patient's prior wishes have power.
You mean an advance decision?
Yes. If a patient has a valid, applicable advance decision refusing a specific treatment, say refusing blood products, that must be honored, even if it means they'll die.
And the principle of proportionality still applies. You can't just do extra procedures for convenience while they're under anesthetic. Absolutely not. That would still be battery. Necessity is strictly limited to saving life and limb.
Okay, what about children? Section 4B. Children and young people.
So anyone under 18 is a child in this context. And the law presumes that those under 16 are incompetent to consent. But, and this is a big but, they can prove otherwise through something called Gillick competence.
Right, the Gillick test.
The child has to show enough maturity and intelligence to fully understand the specific decision they're being asked to make. So a savvy 14-year-old might be Gillick competent for something simple, but probably not for a major amputation. It's decision-specific.
And if they're not competent, it's the parents who consent.
Or someone with parental responsibility, yes. But even then, you must still explain things to the child in a way they can understand and take their views seriously. You have to respect them as a person.
But there's a really interesting legal limit here when it comes to refusal, isn't there?
There is. In English law, a Gillick competent child can consent to treatment, but they cannot unconditionally refuse life-saving treatment. The courts can override their refusal until they are 18.
That feels like a significant limit on their autonomy.
It is. It prioritizes the preservation of life over the developing autonomy of the minor, but it also provides a strong emergency anchor. If you have a 15-year-old in a life-threatening situation and you can't get parental consent, necessity allows you to proceed. The source notes that in 800 years, no one has ever been successfully sued for saving a child's life in an emergency.
That's a pretty reassuring precedent. Okay, finally, let's talk about adults, 18 and over.
The starting point here is the presumption of capacity. Every adult is presumed to have capacity unless there's a good reason to believe they don't.
And if you challenge that presumption, you have to use the two-stage test from the MCA.
You do, and both stages must be met. Stage 1 is the functional test. Is the person unable to make this specific decision? Meaning, can they understand, retain, weigh, and communicate?
And if they fail that functional test?
Then you move to Stage 2, the diagnostic test. Is their inability to make the decision caused by an impairment or disturbance of the mind or brain? Like a psychiatric illness, a brain injury, dementia, something like that.
It's so important that both stages have to be met.
Crucial. And you have to stress that having a psychiatric illness does not automatically mean you lack capacity for surgical consent. Capacity is decision-specific. You still have to test them on the functional stage for that particular decision.
This brings up another huge point of confusion, the role of relatives. Clinicians often ask family members to sign consent forms.
And they absolutely shouldn't. A relative cannot give consent unless they are a formal court-appointed deputy, which is very rare. Their vital role is to give you information about the patient's values and wishes to help you figure out what's in their best interests.
Right. Okay, let's do our second check-in question on that two-stage test.
Good idea. So here's the scenario for you listening. An 18-year-old patient is actively psychotic and is refusing a necessary life-saving appendectomy. Is their refusal immediately valid?
Take a moment. Think about those two stages. Does the psychosis automatically mean their refusal doesn't count?
The psychosis meets the diagnostic test, yes. There's an impairment of the mind. But you still have to apply the functional test. Can they, despite their psychosis, understand that they have appendicitis and will likely die without surgery? If they can understand that and still refuse, their refusal is valid. If the psychosis means they can't process the basic facts at all, then you treat in their best interests.
The functional test is the gatekeeper, and that's a perfect lead-in to Section 5. Best interests and withdrawing life-sustaining treatment.
This is where the stakes get incredibly high. When a patient lacks capacity, you have to act in their best interests. But that isn't just about what's medically best. It's about their welfare in the widest sense.
Medical, social, psychological. You have to consider their previous wishes, their values, their beliefs.
You're trying to put yourself in their shoes. There's a powerful case study, Mrs. P, from 2017. She was in a minimally conscious state, and the team wanted to insert a feeding tube. Her daughters objected, saying she would never have wanted that.
And what was the key guidance from the court?
The court said that what the patient would have done is a crucial piece of evidence, but it is not automatically the same as what is in their best interests now.
Why that distinction? Why isn't her past wish the final word?
Because her prognosis might have changed, or there might be aspects of her current state she couldn't have foreseen when she made that statement. The decision has to be a dynamic assessment of her welfare today, heavily informed by, but not absolutely bound by, her past wishes.
This gets applied most dramatically when we talk about withdrawing treatment, especially things like food and water, clinically assisted nutrition and hydration, or CAH.
Yes.
Yeah.
Historically, stopping CNH was seen as such a big step, it always needed a court's permission. But a Supreme Court ruling concerning a Mr. Y completely changed that. The court clarified that CNH is medical treatment, just like antibiotics or a ventilator. It's not in some special category. So the new rule is that if the clinical team and the family all agree that withdrawing treatment is in the patient's best interests and they follow the MCA process properly, they can do so without going to court.
That must be a huge relief for families.
It is. It avoids long, painful, and expensive court battles. But, and this is the crucial safety net, if there is any disagreement, any conflict of interest, or if the decision is very finely balanced, you absolutely must apply to the court. The court is still the final arbiter in difficult cases.
Okay, what about DNA CPR decisions? Do not attempt cardiopulmonary resuscitation.
The legal duty here is all about discussion. A doctor has a legal duty to discuss a DNA CPR decision with a patient who has capacity or with their relatives. The only time you can avoid that discussion is if it would cause the patient actual physical or psychological harm, not just distress.
And finally, in this section, this very tricky concept, the doctrine of double effect.
This is the legal justification for giving a patient in palliative care a dose of painkiller, like morphine, that you foresee might shorten their life by depressing their breathing.
So how is that not euthanasia?
It comes back to intention. The action is lawful only if your sole intention is to relieve pain. The shortening of life is a foreseen but unintended secondary effect. But there's a fine line. If the dose is so large it's virtually certain to kill, a court could infer that you intended to kill. So in those situations, you have to consult widely with colleagues and ethics committees to show your primary intent was purely palliative.
A very fine line indeed. Okay, let's move to our sixth section, confidentiality, trust, and the public interest.
The starting point is always the primacy of confidentiality. You hold patient information in trust. You don't discuss it with anyone, relatives, police, without explicit consent. Breaching that trust has serious professional consequences.
But what about within the healthcare team? Information has to be shared for treatment to work. This is often justified as implied consent.
It is, but legally, that's on shaky ground. Academic lawyers are pretty skeptical. They'd argue the patient is just acquiescing, not truly consenting, because they were never told exactly who would see their information. It's a caution to only share what's strictly necessary.
But confidentiality isn't absolute, is it? There's the balancing act against preventing serious harm to other people.
Exactly. You can breach confidentiality if keeping it secret would pose a serious foreseeable threat to the health or safety of others.
The source gives a really complex, real-world case for this. ABC v. St. George's Healthcare.
A very challenging case. A father had Huntington's disease and forbade his doctors from telling his pregnant daughter. She later sued, saying they had a duty to tell her about her genetic risk so she could make decisions about her pregnancy.
And the court agreed.
The court confirmed that the doctors did have a legal duty to perform that balancing act. They had to weigh the father's confidentiality against the daughter's interest in avoiding serious harm. The court said their decision not to disclose would only be justified if it was reasonable.
Wow. That puts an incredible burden of judgment on the doctor.
It does. It shows that while confidentiality is strong, it's not unbreakable when faced with the risk of serious, foreseeable harm to someone else.
This tension also comes up when dealing with the police. What's the general rule about sharing information with them?
The default is you don't. Lord Denning's rule says clinicians have no general obligation to hand over confidential information just because the police ask. The police need a court order.
But there are exceptions where voluntary disclosure is considered okay.
Yes, but the bar is very high. Guidance says you should only consider it if the crime is grave. We're talking murder, rape, child abuse, and if not disclosing, would seriously hinder the investigation. Things like theft or fraud don't meet that threshold.
And then there are some times when you must disclose by law.
Right, statutory requirements. You must disclose information to identify a driver in a traffic offense. You must report suspicious terrorist activity. And in many places, you have to report admissions for knife or gunshot wounds to alert police to an armed person at large.
Okay, so for our final section, we're looking at the bigger picture: governance, regulation, and standards of excellence.
This starts with the moral tension in research. Surgeons have a duty to improve care for future patients through research, but that conflicts with the duty to act only in the best interest of the individual patient in front of you now, because research involves unknown risks.
Which is why research has to be so tightly regulated by external ethics committees.
Exactly. They ensure there's proper informed consent, that the benefits outweigh the risks, and that patients are protected.
But what's the difference between formal research and just a surgeon being innovative in the operating theater?
It's a key distinction. A major innovation, a whole new procedure, requires formal scrutiny. But a minor innovation, something you have to come up with on the spot because of a tricky clinical situation, is allowed if it's necessary, proportionate, done in good faith, and would stand up to peer review.
It's about maintaining standards.
It is. Which means only offering treatments you're properly trained for and constantly auditing your own results. If your outcomes are good enough, you have a duty to stop, get more training, and improve.
And this extends to your colleagues. The duty to monitor your peers.
This is a tough one, professionally, but ethically it's crystal clear. If you know a colleague is exposing patients to unacceptable harm and you do nothing, you share in the moral responsibility for what happens next.
Closing ranks is not an option.
No. The duty to the patient has to come before loyalty to a colleague. And that all ties back to that final act of disclosure. When something does go wrong, you tell the patient what happened. You put them back in a position of knowledge so they can make their next choice.
We have covered so much ground. This is really the ethical toolkit for every surgeon. Let's just quickly review the 3 pillars we've talked about.
Okay. First, autonomy. The patient's absolute right to choose and to refuse, even if their choice seems unwise.
Second, disclosure. The need for thorough, personalized communication, not just a signature, to avoid the legal claims of battery and negligence.
And third, balance. That constant, difficult tension between strict confidentiality and the duty to prevent serious harm to other people.
These principles are the framework for good ethical surgery. Use this deep dive as your foundation, and then really get into the text of Baily and Love to cement these ideas.
And here's a final thought for you to take away. Reflect on that case of the elderly man with the septic leg. He lacked capacity, but a judge ruled that his previously expressed feelings and values, his dignity, his identity, outweighed the clinical drive to save his life by amputating his leg.
It really makes you think.
It does. It raises the question, in the hierarchy of surgical ethics, is the preservation of a person's identity and dignity sometimes more important than the preservation of their physical life? Something for you to ponder as you continue your studies.
A profound question to end on. Thank you for joining us for this crucial deep dive. Until next time, keep learning.